I think we're all ready to resume now, so we'll return to Mr. Orr. Mr. Orr.
My Lords, finally, on prevention of access, we echo Mr. Lockie's submission that general restrictions on free movement, such as those contained in Regulation 6 of the 26th of March regulations, did not prevent access to premises within the meaning of the AOCA extension. We submit that the court below was correct on this point for the reasons it gave in paragraphs 328 and 329 of the judgment. It follows, we submit, that the court below rightly found that there was no prevention of access to premises in the case of businesses that were permitted by the March regulations to remain open. And that includes Category 3 and Category 5 businesses, which account for 87% of the policyholders of the Zurich policies in issue in these proceedings. Lords, I then turn finally to the meaning of action. Zurich submits that the court below was correct to find that the word action in the AOCA extension connotes steps taken by a competent authority which have the force of law. On this point, Zurich relies on the submissions made by MS Amlin and Hiscox on the force of law issue, as well as the points made in Zurich's own written case. I make the following brief points at this stage. First, the narrow meaning to be ascribed to the term action in the AOCA extension is apparent, we submit, when the extension is read in the context of the Zurich policies. The AOCA extension does not refer to advice, in contrast to the phrase order or advice of the competent local authority, which is the trigger for cover under the notifiable diseases extension. The draftsman's choice of words should be taken to be deliberate. Second, in the context of the AOCA extension, the term action is naturally read as connoting steps which have the force of law, because only such steps prevent access to premises. Guidance or advice which gives an insured the option of complying does not have that effect. Third, the construction adopted by the court below promotes commercial certainty. The FCA's contention that action encompasses not only actions which have the force of law, but also instructions expressed in mandatory terms, is a recipe for uncertainty and dispute. Fourth, the FCA's arguments are, we submit, driven by hindsight. That is wrong in principle. The policies must be construed by reference to the background knowledge that would reasonably have been available to the parties at the time of the contract. And finally, my lords, a brief word on Mr. Edelman's argument, trying to link the force of law point to the FCA's first ground of appeal, namely the pre-trigger downturn point. Mr. Edelman argues that when these 2 points are combined, the construction adopted by the court below would reduce policyholders' claims to zero, even though cover was subsequently triggered by legislation having the force of law. Now, Zurich is not concerned with the first ground of the FCA's appeal. Nevertheless, to the extent that such an argument is relied upon to construe the AOCA extension in the Zurich policies, Zurich makes clear that it does not suggest, and never has suggested, that closure of a business in the period immediately preceding the introduction of legislation by the government, for example, on the 20th of March in advance of the 21st of March regulations, would of itself establish a trend that a loss adjuster could use to adjust a policyholder's claim to zero. Mr. Edelman's argument to that effect focuses on the short periods of time between first, the announcement issued by the government on the 20th of March and the regulations introduced on the 21st of March, and second, the announcement issued by the government on the 23rd of March and the regulations introduced on the 26th of March. From Zurich's perspective, the notion that loss of revenue during those periods would be relied upon by a loss adjuster to reduce a claim that was covered by a policy to zero is fanciful. This, in our submission, is unjustified scaremongering. The argument is also unsupported by any evidence. There is no evidence before this court, and there was none below, suggesting that loss adjusters would approach the establishment of a trend in the way now alleged by the FCA. The pre-trigger downturn point does not therefore support the FCA's argument as to the proper meaning of the term action in the Zurich AOCA extension.
Can I just ask for clarification, Mr. Orr? Are you restricting your submission to establishing a trend, reducing the loss to zero, or are you making a wider point that it wouldn't be relied on as establishing a trend at all?
No, my lord, it would be part and parcel of the circumstances that would need to be taken into account. But I am responding to Mr. Edelman's interorum argument that it would have the effect which he said would be to reduce policyholders' claims to zero.
Yes, so it might reduce the loss to some extent.
Indeed, but on the face of it, not a significant extent, because a trend is something that happens over a period of time. Lord, so that was all I was going to say, unless I can assist your lordships further, and we submit, for the reasons I've given, grounds 2 and 3 of the FCA's appeal should be dismissed.
Thank you very much, Mr. Orr. Well, I think it's now time for Mr. Keeley to go over the top, as he put it.
I'm going to hope to stay there, my lord, and in fact invade the trenches opposite me successfully. I'm going to address 5 to 6 points in my reply. I say 5 to 6 because it'll really depend upon how interventionist your lordships are. But I'm going to start quite slowly, and probably I'll gallop towards the end. The first point, my lord, is quite important. The gauntlet was fairly and squarely thrown down in front of Mr. Edelman's feet. I think he bent down and tried to pick it up. If he did, he failed to get up properly again, my lord. The gauntlet was, my lord, that Mr. Edelman had not come up with any insurance case in this country, or indeed in Scotland, where something has been held to be approximate cause, which, however, was not a but-for cause. All Mr. Edelman can point to are defence costs authorities, and they simply don't help him. They turn on the wording of the relevant defence costs expenses provisions. There is nothing in them that refers to causation in any way, shape or form. They provide no support for there being approximate cause where there is no but-for cause. I can take your lordships and invite your lordships to go to the Zurich and IEG case, a case very close to Mr. Edelman's heart since he was in it. It's at E divider 21 at 494. It's also a convenient authority because it refers to New Zealand Forest and its policy provision. And the reason I take you straight to 494 rather than to the beginning is because that's where the relevant defence cost provision exists in the policy before the court in that case. As your lordship sees at paragraph 13, each of the Midland policies issued during the 6 years when it was on risk provided that. And if your lordships go to the last sentence on that page, the company, that's the insurer, will in addition pay claimants' costs and expenses and be responsible for all costs and expenses incurred with the consent of the company in defending any such claim for damages. If your lordships could now turn to page 503, to paragraph 37, you'll see a similar type clause in the New Zealand case. If your lordships look at paragraph 37, as regards defence costs, IEG relies on reasoning adopted by the Privy Council in New Zealand. If you could go down, my lords, to letter F, this covered, quotes, all loss which such officer has become legally obligated to pay on account of any claim made against him for a wrongful act. Both provisions, therefore, depend upon a legal obligation. The wordings provided, my lords, a complete indemnity. I think I've lost Lord Leggett's back. The wordings provided a complete indemnity. They compelled one obvious conclusion. The costs having been incurred by the insured, and the insured having incurred a liability in respect of them for the defence of covered claims, it was a complete irrelevance that they might also have inured for the benefit of uncovered claims. And your lordships, I'll give you the reference to paragraph 38 as well. Even so, my lords, if you apply the but-for test to the clauses, as in Zurich, would the claimants have suffered the loss which they claimed indemnity but for having incurred the costs and expenses with the consent of insurers in defending such claim for damages? Of course not. The answer is no. The but-for test was satisfied insofar as it ever needed to be asked. Whilst we're on Zurich, my lords, I want also to point out to your lordships the relevant paragraphs which dealt with the insurance fallout, rather like a nuclear fallout, the insurance fallout of the departure from the but-for test in the Fairchild enclave. There are certain paragraphs which I'll refer you to, and certain paragraphs I'll read. Could I read paragraph 102 at page 525 in the judgment of my Lord Hodge? These are all paragraphs which I cite to you almost in terrorem. In other words, don't mess around with the but-for test unless it is absolutely necessary and vital so to do, and in this case, don't. And I'm going to develop that submission in a more elegant form in a moment. Paragraph 102. I have found this a difficult case, not least because I'm generally averse to developing the common law other than by the application of general principles. I've shared the concerns which Lord Newburgh and Lord Reid have articulated, but we are where we are, and that's a rather sad sentence. The law has tampered with the but-for test of causation at its peril. See the Sinkowitz and Grief case, Lord Brown, etc. The Fairchild enclave exists. The courts in Fairchild and Barker and the trigger litigation, for obvious reasons of policy, have developed a special rule of causation to do justice to the victims of wrongful exposure to asbestos fibres who've contracted mesothelioma as a result. Having done so, the courts must address the consequences of that innovation. For your reference, could you also look at my Lord Hodge at paragraph 109? That's just a reference. Lord Sumption at 114. Lords Newburgh and Lord Reid, who gave a joint judgment. Could I take your lordships to paragraph 193, which your lordships will find, I think, at page 564 of this bundle. The creation of an ad hoc exception from established principles governing causation in order to provide a remedy to the victims of mesothelioma was in the first place likely to result in uncertainty as to the legal rationale of the exception, as distinct from the social policy of enabling victims of mesothelioma to obtain a remedy against negligent employers, and the consequent breadth of that exception. The rationale could not be merely the impossibility of establishing the cause of an injury, since such a wide exception to the general rule governing causation would destroy the rule. Can I invite your lordships to go on, and then, as your lordships see, Lord Brown referred to the unfortunate fact is that the courts are faced with comparable rocks of uncertainty in a wide variety of other situations too, and that to circumvent these rocks on a routine basis would turn our law upside down and dramatically increase the scope for what hitherto have been rejected as purely speculative compensation claims. And I think, my lord, if you go to the last sentence in that paragraph, secondly, the introduction of a novel test of causation in tort was bound, given the legal and commercial connections between different areas of the law, to give rise to a series of difficult questions and consequent uncertainty as the ripples spread outward. Oh, I'm so sorry, my lord. It was being pointed out to me, something was being pointed out to me, and I didn't know it was you.
That's fine, Mr. Keeley. I was waiting till you'd got to a good point in the passage. But what I wanted to suggest to you is that the problem in Fairchild and other such cases is not the application of the but-for test, It wasn't a case in which there were multiple causes sufficient to result in loss. The problem was that in that enclave, although it's put politely as a weak test of causation, actually what happened was that the need to prove any causal link between the particular negligence and the loss was abrogated. And that's not a core problem, it's just a case of dispensing with causation and satisfying yourself with an increased risk, which doesn't amount to a causal link.
Well, it depends again on your perspective. I mean, Professor James Stapleton would say that an increased risk is a causative connection. Professor Lord Burrows would disagree, my lord, with that. But neither of those two persons is here. But certainly, in that case, it might be said that no causal link could be proved, although there possibly was a causal link between at least one tortfeasor's actions and indeed the disease. In relation to the I'm so sorry. Was your lordship going to say something?
No, I was just agreeing with that proposition.
In relation to the but-for test, dare we say it, the causative link cannot be proved either, because unless you have something which causes, unless you have A causes B, B is not caused by A. So it's an even more fundamental point. In fact, the Fairchild Enclave at least had one tortfeasor who did something which was causative of the victim's mesothelioma. In our case, if you ask the question, which I'm going to repeat ad nauseam until you tell me to shut up, which is, did the peril insured against cause the loss? The answer is no, there was no cause as a result of the insured peril. There was a cause. If you're an epidemiologist, there was a cause, and the epidemiologist can investigate the cause. But in terms of the contractual question...
You say, do you, Mr. Keeley, in the case, say, two fires, each started off and the house gets burnt down. This is a heart and honorary example, and either fire on its own would have been sufficient to burn the house down, but two were started. You say there was neither fire caused the loss. That's what you say, is it?
Absolutely not, my lord. That's a terrible example. It's a case of two wrongdoers, each of which causing a fire, and the fire burns down the building in circumstances where, if there had been one wrongdoer, the victim of the fire would have recovered. But in circumstances where there's a proliferation of wrongdoers, the law seems to think, or the but-for test seems to think, that there is no wrongdoer. And that is so absurd that the law, in the case of tort, as a policy reason, in the case of two wrongdoers, makes an exception.
Well, let me dispense with wrongdoers. There's a strike of lightning which starts a fire, and a wrongdoer also starts a fire, if you like. We don't say that the lightning wasn't the cause of the burning down, because it would have burnt down anyway. Or
well, actually,
neither caused it.
No, I'm sorry, my lord. Professor Lord Burrows would tell your lordship that in the answer to that particular example, the natural cause has resulted in the fact that the unnatural cause is no longer a cause at all. If your lordship looks at Lord Burrows's book on causation, he will say that if there is a human-made cause and a natural cause, and the loss would not have occurred but for the natural cause, then what the person who would be the tortfeasor has no liability as a result of the natural cause, as it were, intervening.
So what neither did cause the loss in that example?
No, absolutely not. Because again, you're doing the wrong thing, dare I say it, my lord. You're asking the wrong question. Did the wrongdoer cause the fire? Answer is no. No, because but for the wrongdoing, the fire still would have occurred. My lord, I hate to say this because I can debate this with your lordship for probably the next 2 hours, and I just don't have the time. And actually, that's a very important point, my lord. Could your lordship, just for your reference, the Karsloggy case, F14229, Mr. Justice Hamlin's analysis in the Orient at E31928, C. Clark, F601292, McGillivray, E511453, footnote 27. Now, the concern I have, my lords, and I'm going to have to jump in, really dash now, and so I'm now at a gallop, my lord, and I might actually lose control in a moment and come off, but it doesn't matter.
Now, I'll respond to your request not to ask any more questions, Mr. Keeley, and give you a free run for the last furlong.
Well, well, I hope it's longer than a furlong, my lord. Anyway, Mr. Edelman referred to Galoo in the Australian cases referred to in it. You have to read them very carefully. I'm sorry, they don't say what Mr. Edelman suggests. They don't say but for causation is unnecessary, only that it's insufficient. My lord, I've got a very important point to make, which I'm now going to rush through into, if I may. Your lordship, let's say my lord, Lord Legate, has been postulating quite often the concept of two concurrent independent causes. Despite everything I say about but for, you're throwing me out with the bathwater, as it were. If you discard the but for test in a contractual context, you discard the need for a factual causation link between what's insured and the BI suffered, the business interruption. Now, that is dangerous. Look at Fairchild. I've shown you the appellate court's warnings. The recognised exceptions are limited indeed, and that includes material contribution cases where, for example, my lord, there is a scientific limitation in being able to prove causation. See McGee and Bonington castings. Now, the courts have in those cases, and I say this politely, manipulated the rules of causation for policy reasons. Those are tort cases. They are cases of multiple wrongdoers. This is a contract case where the parties have contracted against the background of established insurance legal principles on proximate cause and but-for. It's a contract case where soi-disant policy reasons don't come into it, as they might do in tort, to permit the court to manipulate the rules. Contractual bargains are not to be rewritten because of difficult cases. And this, my lord, is not the case for developing some new, previously unrecognised exception to but-for. There are two reasons, predominantly. There are an awful lot I got written down, but I'm going to select two. Firstly, the FCA has expressly said that it is not relying on any exceptions to but-for. Two references, trial, day 1, page 92, lines 2 to 7, FCA's written respondents case, paragraph 8, bundle B, divider 10, page 336. I'm going to read the last very quickly. This case is not and never has been about manipulating the legal rules of causation as occurred in the extreme circumstances of Fairchild, or about making new law with wide-reaching effects in tort law and contract law. It's not even about making new insurance law. That's the first one. The second reason, my lord, as I dash, there could hardly be a more dangerous invitation to the highest court of the land in an expedited hearing, which is ostensibly about the construction of numerous individual wordings, for my lords, these judges before me, to go off and discard the but-for test in a proximate cause insurance case. If your lordships really had wanted to do that, you should give me about 2 more days of legal argument, where I take you through all the legal texts, Professor Stapleton, which your lordship, I know, my Lord Legate knows all about, because 2 of his examples to me were examples from Professor Stapleton's Law Quarterly Review, as I recall, Professor Burrows, etc. I'd have to dash on, my lord, I don't have time. But this is not the case. But since Lord Legate is taxing me mercilessly, I'm going to deal with Lord Legate's 2 categories in relation to wide area damage. It's what I think he asked, was it Mr. Edelman? I think it was Mr. Edelman. The first category that your lordship put is where the sheltered hotel, it was a sheltered hotel, I believe, was closed for 2 weeks due to damage, but even if it had been open, nobody would have come to the hotel. So a one soi-disant concurrent court, independent. The damage to the hotel, but there was also damage to the city, are therefore concurrent independent causes. You know our position, but for means that there is no coverage. I won't repeat the submissions, but even accepting for the purposes of this bad argument that I'm wrong about it, your lordship's first category is limited to true cases of concurrent independent causes. And that question is entirely fact-specific. Secondly, when the case ceases to be one of concurrent independent causes. In other words, damage may not be fully repaired, but whatever is the state of the condition of the hotel is not such as to cause the business interruption. At that moment, you come to my Lord Legate's second category. But nobody comes to the hotel because of the surrounding area damage. In our case, on any view, that loss is caused by the uninsured effects of the hurricane and cannot be recovered. Mr. Edelman said no. He said that even after the damage ceases to be a cause, you ask, quotes, what would have happened in a normal world with no hurricane anywhere? My lords, we say that that is just the wrong answer, and that is the pervasive element of the entirety of the FCA's case against my clients on proximate cause and but-for cause. Finally, my lord, because I'm dealing with the Orient Express and physical damage. Physical damage is much more tangible. You can see it, you can feel it, much more than disease. Applying my Lord Legate's categories is not at all easy when you're talking about disease. Let's say you've got a radial area of 25 square miles. Now, it may be at some stage that one could describe the illnesses or the cases of illness within that area as being of some causative impact. But there will come a time, my lord, I've got 2 minutes left, I'm told, it's rather like one of these competitions. There will come a time when that disease or the illnesses in that area simply will have no causative potency whatsoever. At that moment, that area ceases to be a concurrent independent cause. Right, last point, my lord, interdependent causes. Those are the only instances where you see that the but-for test is properly applied to concurrent causes. Never anything other than interdependent, see more Lord Hamlin. And finally, my lord, the Silver Sea, which is, it seems to me, my learned friend's best and only case. It is a case of such irrelevance that not only the court below, but also Mr. Justice Hamlin, as then he was, almost so described it. It was a decision on its own facts, based upon particular expert evidence that was heard. It was concurrent causes were not even argued. It was common ground that the events of 9/11 and the State Department warnings were concurrent causes. There was no argument on but-for, there was no argument on interdependent, there is no legal principle in that case of relevance to this. I'm afraid I will tell you all about windfall profits being a terrible point. Look at Riley. I'll tell you about more serious the fortuity, the less the cover is an awful point as well. I just don't have time to cover so many awful points made against me. It is a great shame. But at least I've covered, to a degree, but-for and proximate, which is a bad point. I think I'm out of time.
Thank you very much, Mr. Keeley. In that event, we'll turn next to Mr. Crane.
Can your lordships see and hear me?
Yes, we can, thank you.
My lords, I've got the standard allocation of 20 minutes, in which I have to reply on my appeal and respond on Mr. Edelman's appeal on QBE2 and QBE3. And I'm going to spend the vast bulk of that time addressing causation on a hypothesis. And the hypothesis is that your lordships are with me on the proper construction, on the construction of the disease clause, with the result that I'm addressing causation on the hypothesis that the insured peril is not the disease generally, but occurrences or manifestation of the disease within the radius area, such as to have caused the business interruption. But before I do that, I can't completely ignore the construction issue. On QBE1, I'm going to leave it apart from making these points. And they all involve hypothetical questions. And I'm asking your lordships to imagine that someone had been asked what this clause meant before the present extraordinary crisis. And I suggest that had that question been posed, say a year ago, the person in question would have replied without too much hesitation that it was intended to provide cover, business interference caused by the manifestation of a notifiable disease within the premise or within 25 miles thereof. And that person may have gone on to say that that impression is reinforced by the location of this clause in the contract amongst immediate neighbours providing local cover. Now, assume the same person was asked a second question, which goes like this. How about a disease like SARS, which might spread unpredictably and have widespread effect? To that question, he would have replied, well, if that's a risk they had in mind, it looks like the radius limitation was intended to ensure it was only the impact on the business and outbreak of disease within the specified area which was covered. Otherwise, the radius provision wouldn't have made much sense. Now postulate a third and final question, which goes like this. Well, it may seem utterly inconceivable, but say the government was to lock down people and businesses nationally without regard to the prevalence of disease in any particular area. Don't you think the cover would be triggered in that event if and when a single case of the disease manifested itself within the insured perimeter? And he'd have replied, well, what's the sense in that? If that's the risk the parties had in mind, the radius limit makes no sense. Why should cover in that event depend on the wholly arbitrary contingency of disease entering, perhaps in one case, in the specified area? If that's the risk you wish to guard against, you need cover against disease generally. So well, those are my submissions on QBE 1, for what they're worth. QBE 2 and 3, I'm going to take an even more radical approach. I haven't addressed the proper construction of those clauses at all orally, and I don't have time to do so. What we do, however, is a 10-page respondents case at tab 16 of file B, page 612, which sets out a number of, we would submit cogent submissions on the proper construction of this clause. The effect of which, or the outcome of which, is that on any orthodox application of the rules of construction, the result hit upon by the court below was inevitable. Now, before leaving construction, can I just make two further points that are relevant to causation and which have gained profile or at least emerged in the course of exchanges between Mr. Edelman and the court yesterday. The first is this: it has never been QBE's case that within the specified area, their disease clauses cover a single occurrence of disease only. If by occurrence is meant a single case of notifiable disease. The court below understood this perfectly, that what we were insuring were cases, a case or cases occurring within the specified perimeter. And we can see that at paragraph 235 of the judgment, file C, page 104. I'll be coming back to this in a different context. 3 lines down, paragraph 235, the court said this: as we have found that this clause, unlike others we have considered, is drawing a distinction between the consequences of the specific cases occurring within the radius and those not doing so, because the latter would constitute separate events, we consider that insurers would only be able to recover if they could show that the cases within the radius, as opposed to anywhere elsewhere, were the cause of the business interruption. And indeed, if one looks at, I won't take you there because it's not an efficient use of time. You look at Declaration 12.1 in relation to QBE2 at C, tab 1, page 8. You will see that the declaration is framed in terms of either a single occurrence or multiple occurrences. And indeed, my lord, before I leave this point, I would remind the court of the case of Kuwait Airways Corporation and Kuwait Insurance Corporation. At first instance, went to the Lords, but this point was undisturbed. Judgment of Mr. Justice Ricks, File E, tab 26, page 840, at 686, where he discusses the nature of an occurrence in insurance law. And an occurrence may denote an event giving rise to a plurality of loss. For example, the Iraqi capture of Kuwait Airport on the 2nd of August 1990, and the aircraft located there, or the destruction, famous example, the Dawson Fields arbitration, the destruction of 3 hijacked aircraft by the PLO at Dawson's Field in September 1970. So the problem, if it is a problem, of one insured occurrence cancelling another insured occurrence out, both occurring within the stipulated area, simply doesn't arise. Any occurrence or aggregate of occurrences is relevant, provided it has a causative impact on the business, namely, it causes business interruption.
Sorry, Mr. Crane, I don't understand why it doesn't arise, because if you apply a but-for test, because if each is a separate occurrence, as it is, why don't they cancel each other out? If you can say that the but for this particular occurrence, another one would have, the loss would have occurred anyway because of another occurrence.
Because they're all part of the insured peril.
Right.
You can't set insured perils against each other if they are the proximate cause of loss. And
why not? Why not if they're different proximate causes? What, without departing from the but-for test?
Because in a case of, in any causation question, you have to ask whether the insured peril is the proximate cause of loss. And the answer to that, as a matter of fact, is yes. We can forget matter of law for the moment. If in fact the insured peril or perils have acted in combination to cause the loss. Now, it's highly unlikely that one case of COVID-19 or any other notifiable disease would itself cause interruption of the business. It's much more likely that it would be an outbreak in the locality. We accept that. We've always accepted. And Lord, it's never been part of our case that in a case where there is a cluster of disease within the relevant specified area, you take each occurrence separately and examine its causative effect.
No, I realise it's not part of your case. I was just trying to test how you distinguish what isn't your case from what is your case, which is where there's an occurrence outside the area, and why that makes a critical difference to the principle of causation.
Well, it makes a difference for this very straightforward reason, my lord. Once you have an occurrence of disease outside the stipulated area, it's not an insured peril. And that's why when we, I'm jumping ahead, but that's why when we come to consider causation on a certain hypothesis as to the properly identified insured peril, we're comparing the aggregate of cases of disease insured within the area. We're comparing their impact with the aggregate of cases of disease everywhere else in the UK. And I'll justify that in due course, if I may. So before leaving this, I should also correct a submission made by Mr. Edelman, which, with respect, Lord Leggett corrected to an extent. It's never been our case that where the outbreak strays across the boundaries of the insured perimeter, cover ceases. Nor has it been our case that it's only in cases where there is a de minimis occurrence outside the insured perimeter that cover exists. In a case where an outbreak straddles the insured area and a non-insured territory, if I can describe it thus, you have to make a judgment of fact. You have to ask whether the cases occurring within the insured radius are the proximate cause of the interference with the business. And this may involve more or less difficult judgments. Sometimes it's quite easy. In fact, there are just a few cases outside the perimeter. You can infer that any measures taken in response to the outbreak were prompted by cases within the insured area. Conversely, if there's one case within the insured area and a multiplicity of cases outside, the reverse assumption or the reverse conclusion will be the case. So I'd like to leave it at that, so long as there is no ambiguity as to our case. My Lord, can I now turn to causation on the premise that these QBE clauses, properly construed, respond to the insured peril of disease occurring or manifesting itself within the insured perimeter, if that is caused. Now, against that background, I completely adopt Mr. Keeley's submissions on but-for cause and the dangers inherent in disregarding it. But I also maintain that we need no help from but-for causation to make out our case on causation on the hypothesis to which I've referred. The starting point is paragraph 347 of the FCA's Respondents case, and I wonder whether we can just look at that very briefly. It's in file B10 at page 439. It's a short paragraph, but it's very important. It's dealing with concurrent interdependent causes. And it says, in any event, there are concurrent proximate causes only where the concurrent causes are of equal or nearly equal efficiency in bringing about the damage. And the references bear out that proposition. They're to Wayne Tank, the Miss JJ, and a case called Spencer, Handelsbanken, and Dandridge, which I respectfully commend to your Lordship, especially the passage on causation at 1685. I haven't got time to go there, but I would respectfully invite your Lordships to read that statement of orthodox principles of causation by the Court of Appeal. Now, those are concurrent causes, interdependent causes where neither A nor B on its own could have caused the loss. But as I understand Mr. Edelman's case, what he wants to do is migrate from interdependent causes to what he calls independent but interlinked causes, and leave behind the constraints which he conceives are applicable in the paragraph to which we've just referred, namely that where the insured peril and the non-insured peril are concurrent causes, the insured peril must be at least of equal efficiency with the non-insured peril. In fact, if one looks at that paragraph, the conventional position is that once you leave interdependent causation, you have to establish that the insured peril is the proximate or dominant cause. But let's relax for a moment the requirement of dominance and say it must at least have equal efficiency. This is important because if you're going to leave behind but-for causation, you've got to fill the void with something. So our submission is that when you are looking at independent causes, perhaps interlinked, you have to identify that peril, the insured peril, which is the proximate cause of loss, or at the very least, of equal efficiency as a cause with non-insured peril. And that's exactly what the court below did in an exercise which, in our submission, was impeccable. It applied orthodox principles of proximate cause. You can see that, my Lord, quickly. 10 minutes. Great. Go to paragraph 110 of the judgment. At page 69 of C3. C3. That's become familiar to the court. There, the court below identify the insured peril, we say incorrectly, as the disease at large and measures taken in response. But the important point, for my purposes, addressing causation at this moment, is to recognize that the court's articulation of the alternative principle of causation in paragraph 112 proceeds on the basis that that is the insured peril. Now, having reached the conclusion that the insured peril is the disease in the UK at large, but there's no perhaps particular reason to ask whether any particular case of the disease has a causative status more or less than any other case, because the measures taken in response to the disease nationally, on any view, were causative. But when the court, in fact, moved to consideration of causation, having properly or correctly identified the causative peril, we see a completely different approach to causation. And we see that in paragraph 235. This is the court's conclusion on QBE2. And I've read to the court the first sentence or so in a different context. But it's the last sentence which matters. In the context of this clause, given the insured peril, it does not appear to us the causation requirement would be satisfied on the basis that the cases within the area were to be regarded as part of the same cause as that causing the measures elsewhere. That's the indivisible cause of the disease at large, or, and this is the alternative view of causation, or as one of many independent causes, each of which was an effective cause, because this clause, in our view, limits cover only to the consequences of specific events. So what the court is saying there is, once we conclude that the insured peril is the aggregate impact of cases within the specified perimeter, you then have to ask whether those cases cause business interruption. And you compare their causative impact, which in fact is nil, with the causative impact of the disease elsewhere in the UK generally, and measures taken in response. Now, Mr. Edelman says that in coming to that conclusion, they simply forgot about their alternative view of causation. That's palpably incorrect, evidently in causation. Reference to it in the sentence I just read. What the court concluded is that that view of causation was inapposite once they departed from treating the insured peril as a disease throughout the UK generally. Now, that orthodox approach to causation merely asks, what is the proximate cause of the loss? Is it an insured peril? Is repeated at different paragraphs of the judgment. We've been to some of them. 418, my lords, at page 149. Where the court approaches causation in the context of a clause which responds to dangers and disturbance and incident within the vicinity of the premises. You can see the relevant wording at 391, an incident occurring during the period of insurance within 1 mile radius of the insured premises, which results in denial of access. There, it's a local focus. So what you're asking is whether the interruption with the business could be said to have been caused by that insured peril. And we have the same sort of orthodox focus and answer at 437. I won't read all of these because they're to similar effect. 436, I should say, and 437. Paragraph 444, paragraph 467, and paragraph 502. And we'll, I hope this doesn't seem too formalistic a point, but if one reads the FCA's notice of appeal, ground 4, against the court's findings on QBE 2 and 3, I'll leave the court to read it at leisure. It's file A, tab 1, page 125, paragraphs 59 to 62. There's an appeal against the conclusion on construction, but no separate or even linked appeal on the question of causation. Now, that means that actually we were rather taken by surprise when we saw this point advance in the respondents' case on the hypothesis that they lost on construction. We've been familiar with the alternative view of causation, but that was the first time we've seen it articulated that even if they went down on construction, somehow or other, that would get them home. I'm not taking a technical point, I'm just saying that it looks a bit of an afterthought, and I can see why. Yes, Rory.
Well, we've had time to think about it by now, Mr. Crane, but anyway, on the disease, on the construction point, I thought one of the arguments that insurers make, I don't know whether you may not make it, but others do at least, is that it's wrong to construe the 25-mile limit in the way that the divisional court did, because it's not the disease that is being insured, which might just manifest itself partly within the limit. It is occurrences of the disease, and an occurrence means somebody, an individual, suffering from the disease. And we had, you know, my disease isn't your disease and that sort of stuff. Now, exactly so, you're then trying to reverse that on causation and now aggregate the occurrences as though they're a single cause, when in fact the correct analysis is surely that which the divisional court in its alternative paragraph, I think it's 112, which is that each occurrence is a separate insured peril or uninsured peril if it's outside the area.
My Lord, as Mr. Edelman pointed out repeatedly in addressing the court yesterday, QBE have constantly referred, or not constantly, but frequently referred to an outbreak. We've never been scared by that term. And indeed, he invoked it in support of some other part of his argument.
Well, I agree. He tries to have it both ways on the other way around from you on the 2 points.
Lord,
the outbreak insured from his primary argument, but the individual cases if he's wrong about that.
Yes, I've never tried to have it the other way.
All right, well, I'll put the point to Mr. Southey there then.
I'm sorry, my Lord, I didn't mean to talk over you. Whether it's disease manifested or disease occurring, notifiable disease occurring in QBE2 in the premises or within 25 miles thereof, depending on the facts, it may be a single episode or it may be numerous such episodes. It's more likely to be the plural than the singular. And in cases where there is a cluster of occurrences, all insured, then that's the peril which you have to address with purpose of protection. Yep. 1 minute. My Lord, in support of the approach of the court below, I make the following submission. Every policy has to be considered as a standalone contract. The question has to be asked in relation to each policy is, were the insured cases approximate cause of the loss to the business? E.g., the losses caused by and following the government advice of 16th of March and the regulations of 21st and 26th. This is not a case of multiple wrongdoers or even multiple insurers. Each has to be considered on a standalone basis. Second, do not be beguiled by a map of England covered by 20 contiguous circles. We have to consider each case of causation as a standalone proposition, tested in the case of a policy with a 1 mile radius in a remote part of the UK where recorded cases of COVID occurred relatively late in the day, perhaps even after the business had been closed as a result of the 21st and 26th of March regulation. By what contortion of reasoning, we ask, can it be said that the local case or cases within the radius were approximate cause business interruption? How can it be said that the local cases have an equal causative impact when compared with the aggregate impact of all other cases in the UK? It's important to understand how the proviso works when the first case in the relevant area follows commencement of the business interruption. I think this got lost in an exchange on Scilly Isles yesterday. In such a case, Mr. Edelman suggests that the single case within the relevant area is then a contributing cause to continuing business interruption, notwithstanding but that's a grotesque, actually, fiction. In circumstances where the business has been closed, say a week or 2 weeks earlier. That's how it works. My lords, I think I've used my time, and thank you for hearing me out.
Thank you, Mr. Crane. We turn now to Mr. Turner, I believe.
Yeah.
My lord, I'm going to leave Mr. Salzedo to come back to Lord Legate on his perils point, if I may. Can I just start with a preliminary point, which is on a couple of occasions during the course of his submissions, Mr. Edelman treated you to his surmise as to why things had been argued in a particular way at a particular time by RSA. I don't know whether your lordships relied upon Lord Wilson for your racing tips, but if you do or did, please continue to do so, because Mr. Edelman's powers of surmise are consistently wrong. Can I say a little bit more, please, in relation to proximate cause, and pick up Mr. Edelman's example or illustration of the pins on the map, and for your reference. That was day 3, page 51, line 7 and following. And the number of pins in Mr. Edelman's map may not yet be infinite, and may not have been infinite at the point at which the regulations came into effect on the 20th or the 26th of March, as the case may be. But you will recall being told by Mr. Edelman that if one applied the infection rate estimated in the Imperial College report, there would have been about 1.8 million cases spread throughout the UK by the 28th of March of 2020. Now, one can put that in the context, perhaps, of the origins of the proximate cause rule, because Mr. Edelman says each of those pins is a proximate cause of each insured's loss and of the government actions. And if one goes back to the origins of the proximate cause rule, those can be traced back, at least in terms of the encapsulation of the rule, to the late 16th century and Bacon's maxims of the law. And we've inserted those into your lordship's bundle, new bundle L, tab 1, page 3, is the relevant maxim. And the explanatory text perhaps illuminates the point which was raised by Lord Hodge on day 3, my Lord Hodge, at day 3, page 67, lines 3 to 9, which is posing, where Lord Hodge posed the question, that proximate cause perhaps involved a further requirement at the point of enacting the Marine Insurance Act, as opposed to something different from but-for causation. Now, as confirmed in Leyland Shipping, amongst other authorities, the 19th century translation that we see in Bundle L at page 3 of proxima as immediate has been refined to dominant, in the words of Viscount Haldane in Leyland Shipping, or to borrow from Lord Shaw's speech, effective, page 896, E, page 896, or efficient, E, page 895, as causes of the loss. And it is in that context that the parties have so far been unable to identify any case with more than 2 proximate causes in the field of insurance as known to the courts of England or Scotland. That isn't an accident. In our submission, one simply cannot describe one of a series of 1 million or more events, each adding an infinitesimal amount, perhaps a 10,000th of 1% or so, as being an efficient, effective, or dominant cause of a loss. We take Mr. Gazeman's nail bar and position it in, say, Huddersfield, and borrow from Leyland Shipping by way of analogy. That nail bar was not torpedoed by the fact that a Mr. Jones in a village outside Bodmin caught COVID, and on the FCA's case, possibly did so asymptomatically and without ever having been diagnosed as having COVID. The nail bar was torpedoed, as the FCA accepts in its particulars of claim, by the national pandemic and by the measures taken to contain it. And we submit it would simply be an abuse of language to describe Mr. Jones's occult infection being perhaps 1/1,000,000th of the whole, as at the relevant date, and the corresponding PIN as being an effective, efficient, or dominant cause of the nail bar's misfortune. And again, to borrow from Lord Shaw in Leyland Shipping at page E896, Mr. Jones's infection cannot, and I quote, cannot be, I quote, variously ascribed the qualities of reality, predominance, or efficiency. Now, the atomization of cause, which is illustrated so graphically by Mr. Edelman's pins, is, in our submission, wholly antithetical to the notion of proximate cause. My Lord, my next point relates to the RSA1 counterfactual, where Mr. Edelman made a number of forensic submissions, including as to RSA's pleading, where he referred you to a part of the pleading which was dealing with general principles in relation to causation, and not in a part of the pleading that was dealing specifically with RSA1. I've already accepted that it took us longer to get to the light bulb moment than Mr. Gazeman. The forensic approach taken by Mr. Edelman should not obscure, in my submission, the need for the court to consider how, as a matter of principle, a hybrid clause such as the one in RSA1 is intended to operate. And in respect of that, I adopt Mr. Gazeman's submissions before lunch, specifically in relation to the second question that he posed in relation to the 13th chime. Very briefly on the RSA3 disease exclusion, my Lord, it was suggested by Mr. Edelman that the exclusion did not apply to the product liability subsection. That was a submission made by reference to the contents page. It was another sophistical argument, advanced on the strength of failing to show you the wording of the section itself. Section 6 starts at page 1255 in Bundle C, and it starts with, under the heading Section 6, Public Liability, has subsection A, Public Liability, and then 5 pages later, or 4 pages later, on 1261, subsection B, Product Liability. Everything in Section 6 is excluded or is accepted from the exclusion. My Lord, in relation to closure or restrictions and enforced closure, you have our respondents case at Bundle B, tab 17, page 622. And in relation to the example of the insured who decides one morning when he wakes up that he's not, can't be bothered to open the premises, so there's a voluntary closure, and the word enforced being there to emphasise that particular point, well, a voluntary closure wouldn't be covered in any event because it's not a fortuity. Mr. Edelman's attempt to invest the word enforce with some special meaning was actually an attempt to deprive that word of any content. It is there for a reason. It means what it says. My Lord, I am out of time, and Mr. Salcedo awaits.
Thank you very much, Mr. Turner. Well, Mr. Salcedo, I think there are 10 minutes left to you, so your 10 minutes begin now.
Thank you, my Lord. Mr. Edelman confirmed on day 3, page 7, that he did accept that as a result of the words of proximate causation, and he immediately followed that with a statement that underlying all his submissions is that actually it doesn't matter because of our concurrent cause argument. And that response reflects the reality that the argument in this court has demonstrated that the primary basis upon which the court below found against Argenta is unsustainable. Grounds 1 to 4 of Argenta's appeal should succeed. And that leaves for my remaining 9 3/4 minutes, ground 5, the concurrent cause argument. My Lord, in an almost literal footnote to Mr. Keeley's submissions, another authority for Mr. Keeley's correct answer to my Lord Legate's question about fire and lightning is Jobling and Associated Dairies, which is in the bundle at G62 1079. I obviously don't have time to go there. If your lordships think that Jobling is a notoriously difficult case for me to cite, then that only confirms Mr. Keeley's submission that this appeal about the construction of contracts is not the one in which to be reviewing it. My lords, another question that's arisen in this regard, and in relation to which I apprehend that my Lord Legate has a question for me already.
Just to say, Jobling is an example of a case with a supervening cause, isn't it? If I remember, as opposed to one like the fire case where the two fires burned down the house at the same time.
My lord,
Those
is
raise
supervening,
different
but
problems.
well, I see the argument, my lord, but I hope your lordship will concede that there's also pretty strong argument that actually they raise the same essential problem. But it shows that the issue is very context dependent, and that the context of an insurance policy is one in which the crucial question is the construction of the insured peril. And the crucial question is not an abstract question of cause for a philosopher, and it's not necessarily the same question as a question of whether a wrongdoer has caused whatever the consequences are that are prohibited by the rule in question. My lord, I fear I may incur a still further question by coming on to the question what is meant by the words any occurrence. Now, I adopt what Mr. Crane has said about this, but there are some Argenta specific points to add. In opening, my lords, I pointed out that the meaning of any occurrence in Argenta 1 was common ground. I showed your lordships the record of this in the judgment at paragraph 158 at C384. And what I showed your lordships there was that it was common ground that an occurrence was constituted by at least one case, not that each case was itself an occurrence. And that, in fact, reflected common ground on the pleadings between the FCA and Argenta, the relevant parts of which are not before this court because the common ground has not been challenged on this appeal. As the FCA pointed out in its written case at paragraph 166, this common ground is the reason why Argenta has always, in this case, conceded expressly that a local lockdown like the one in Leicester might well be proximately caused by an occurrence within 25 miles of some policyholders. The Argenta cover does cover interruption caused by local cases, including multiple cases in the same areas, which is reflected in the use of the term any occurrence and not the words a case. But that does not transform it, and this I think is the question that my lord was waiting to put to me, that does not transform it into cover for all the consequences of a global or national pandemic, because if it were, there would have been no radius limit. Now, in my opening submissions, I was making the point that the mere fact that multiple cases are part of one occurrence does not mean that all cases in the outbreak, including beyond the radius, are covered. When I was asked by my Lord Legate about this very issue on day 1, page 73, and I made clear then that Argenta still accepted the common ground, that as a matter of, at least accepted that common ground as a matter of substance. Now, my lords, if the transcript is accurate, in the heat of the moment in my answer, I confused cases, occurrences, and indeed outbreaks willy-nilly. My lords, I resile from that confusion, but I do not resile from the substance of the answer, which is that multiple cases are covered, and they are, in fact, as a matter of common ground, covered by the phrase any occurrence. And even yesterday, my lords, at day 3, page 60 to 62, Mr. Edelman insisted on the argument that I've referred to as having been made at paragraph 166 of his respondent's case. The matter has always been and still remains common ground. Now, my lords, the common ground is also the natural reading of the whole phrase in its context. If I can take you back to C5317, you will see or be reminded that 3 of the paragraphs of box 4 use the phrase any occurrence. In each of those subparagraphs, if the word occurrence limited the matter to a single case, they'd all be open to the concern that's been raised a few times by my Lord Legate, that individual cases within the radius could causally defeat each other. And there are 2 answers to that concern. The first answer is to accept the common ground about the meaning of any occurrence, which has been acceptable to all parties and the court below, and at the very least is at least an available and natural reading of the words. The alternative answer, my lords, to go slightly broader into how this works in insurance policies, is to hold that as a matter of the construction of any ordinary insurance policy, if it insures against two or more perils, and multiple insured perils come together to cause loss, even if you need more than one peril to make a sufficient cause of the loss that's eventuated, that is an insured loss. Because otherwise, in any multi-peril policy, take, for example, an all-risks policy, there'll be many factual examples where the self-counselling argument that my lord has made to a few counsel in this hearing would be open to insurers. Now, that can't be right. And the court is then faced with the question, well, is it not right? Because as a matter of construction, if you insure more than one peril, and more than one peril happens and causes loss, that is part of what you've insured. Or is it not right because we need to throw overboard the general law of but-for causation, which has stood the law in such good stead and provided such certainty for English commercial law over centuries? And in my submission, once one poses the question in that way, it's completely obvious what the answer is. Insured perils are insured, even if you need more of one of them to make a loss, but there is no reason to look outside what's insured and add that to the insurance. There's no reason to do that at all. And my lords, the correct starting point is the words of the contract. The underlying fallacy in Mr. Edelman's submissions is to suggest that there was some unqualified disease risk which was insured. And this is the point about outbreak, where my lord says I'm trying to have it both ways by saying we didn't insure an outbreak. My lords, we insured multiple cases within the perimeter. We did not insure any outbreak of which those multiple cases happened to be part. You can call what happened within the perimeter an outbreak, but that does not make it it doesn't make it the wider outbreak. It may even be part of a wider outbreak, but it doesn't mean that what was insured was the wider outbreak. The starting point is the words of the contract, and the inquiry that the court makes in relation to the words of the contract is as to what was insured by those words, not into what remained uninsured. What remained uninsured is simply whatever is left. And what that inquiry reveals when one looks at the words of Argenta 1 or the other simple disease clauses is that there was a comprehensible and meaningful agreement by the parties to ensure the consequences of disease within a 25-mile radius, which, as one sees from what's happened with COVID, is entirely meaningful. It will include local lockdowns, of which there have now been many more since Leicester, where appropriate. But that does not mean that you have to bludgeon the words, or even worse, bludgeon the law of causation into some preconception that the cases within the perimeter are necessarily part of some wider matter, if that matter was uninsured. Your lordship should resist the invitation and temptation to do any bludgeoning. Your lordship should interpret this contract as any reasonable reader would have done when it was made and allow Argenta's appeal in full.
Thank you, Mr. Salcedo. So now we turn to Mr. Edelman for the FCA's reply.
Well, yes, and can I start with causation? And I think I have a full right of reply to Mr. Crane in relation to QBE 2.3 and a right to deal with any new points of law that might have been raised during the course of other submissions, any new points that arise, but not, of course, otherwise a general right of reply, and of course a right of reply on my appeal. I'll start with one observation, though. Mr. Keeley particularly complained about a lack of time and introduced a lot of new material in his reply. Firstly, we have, of course, had 8 days of trial at first instance, with insurers producing, I think, 860 pages of written submissions. They've done another 230 odd pages of submissions for this appeal. They've had 2 days. They've had the opportunity to divide time between them as they saw fit. They've chosen to divide it equally and repeat each other on a number of occasions. That's their lookout. They've had adequate opportunity to make these points. And if Mr. Keeley ran out of time, that's the problem as between the insurers. But turning specifically to the causation arguments that Mr. Crane was making, my lords can now see how it is, once you actually start analysing what insurers are saying about their case, how it all starts to unravel. Because at first they say, well, look, it's individual cases of the disease, that's what it says. And my Lord Legate put to me, it says, well, an illness sustained by, and that's by an individual. But then, of course, they're driven to accept, and did accept, Mr. Crane accepts, and I'm focusing on him because I've got the full right of reply against him, for TBE 2 and 3, he accepts that, well, when it says illness sustained, it doesn't actually mean, can't be intended to mean an individual case. It must mean lots of cases, or at least encompass lots of cases. And that makes sense when you've got a radius of 2,000 square miles. It will also make sense when you've got a radius of 3.14 square miles for the 1 mile cases. And so, although they're a bit nervous about it, what they really do now come to accept is that occurrence does, in practical terms, mean an outbreak of the disease within the relevant policy area. And Mr. Crane accepted it. I haven't got a right of reply to him, but I will note perhaps that Mr. Salzedo has just accepted it, and he's got the same wording, illness sustained by any person. So it's the nature of the risk which is driving them to this concession. And once they make that concession, you then have an outbreak in the relevant policy area, which is in fact an indivisible part. You have an indivisible outbreak in the country, of which the outbreak there isn't really a separate outbreak in the relevant policy area. It just happens to be part of the national outbreak. And that's where you then get to the court's conclusion on construction. Well, if this is contemplating outbreaks, not odd cases, but is contemplating at least including outbreaks, and everybody, and they're accepting that conclusion because that's what happens within the relevant policy area. They know it's not going to be one case, it's going to be a whole cluster of cases in the area. Then you're driven to the conclusion everybody must have contemplated when you're dealing with this sort of risk, that if there was an outbreak like that, there was every chance that it was going to be outside as well as within. And then you do then ask the question, is it, and this is what the court posed, was it really intended that you should then get this arbitrary response of the policy depending on the precise shape of the outbreak and whether it does or doesn't straddle the boundary? Is that really what the parties intended when they are ensuring this type of risk? And so that one sees it in a nutshell with what Mr. Crane and Mr. Salzedo actually were driven to accept, to get away from the obvious artificiality of an individual case. Our alternative concurrent cause cases simply, well, if you want to go down the artificial route of treating these all as individual cases, that's where you get to. But actually, if it's all an indivisible outbreak and it just happens to be present in the relevant policy area, that's what the policy is contemplating. And you don't, for that, you don't need any rules of causation at all. It's quite simple. And I can illustrate this, and this is not replying to Mr. Keeley, it's just illustrating the point that I was making with two fires, one of which is caused by an insured peril and one of which by an uninsured peril, which merge and cause the damage. Now, the critical point about insurance is it's all about the transfer of risk. It sounds facile to say that, but it is important to distinguish the nature of the contract as being the transfer of risk. And it's the transfer of risk of the insured peril from the policyholder to the insurer. The insurer accepts that risk for a price, the premium. this is not about remedies against a wrongdoer who causes injury. It's about transfer of risk. And with all respect to all the submissions that Mr. Crane has made, if you have a situation in which a loss is caused by the overall effect of something, which is partly caused by an insured peril or concurrently caused by an insured peril and an uninsured peril, then that is covered by the policy unless the non-covered element is excluded. And so in the fire example, where you have two fires which merge, the simple answer would be that if the other fire was caused by an excluded peril, there is no cover. If it's caused by an uninsured but not excluded peril, it is covered. And that is, let's face it, and that's why insurance is different, because it's a transfer of risk. And if the risk has manifested itself in that way, you have insurance. So that we say is a quite simple analysis. And here what you have is the outbreaks in each area forming part of one indivisible national epidemic. And it's like the fires merging. Fire is raging in each policy area. But in fact, it's a national fire. It's all one big fire. Fires may not be the great analogy, but because disease is a different thing. But if one's trying to draw some analogy, that's it. And the fact that there are different, the fire, you can see the fire in different parts of the country, doesn't mean that that fire is ceasing to be causative of the damage that the whole fire, the merged fire, is causing. That's what I wanted to say in response to Mr. Crane on the general point. On one other point, on the construction of his policies, where he goes wrong is in our submission is to read paragraphs of the judgment in isolation. One has to look closely at paragraph 102, page 67. This is on his answer to my causation point and his reliance on what was said in paragraph 235. If one goes to 102, when discussing the RSA policy, you'll see that what the court, how the way it approaches construction is it asks 5 lines down or so, extension 6A is not expressly confined to cases where the interruption has resulted only from the instance of notifiable disease within 25 hours, as opposed to instances elsewhere, nor in our view does the language used in this clause implicitly have that effect. And if you read the judgment as a whole in context, and then you go to paragraph 235, which Mr. Crane relied on, in our submission, you read it as a whole, it is apparent that what the court is doing, and if you read everything as a whole, what they're doing is they're treating QBE 2 and 3 as being an exception, as if it said resulted only from the instance of disease. And it's only in that way that you can make sense of their conclusions about causation and their answer here. What we say is if that was an extra stage in the reasoning that they didn't need, that they missed out. They might have said, well, this doesn't fit with the other construction, but they then needed to consider the next question: does it, if it applies to looking at cases locally and isn't considering this broader outbreak potential, then is it nonetheless something which has to be only within the policy area? And they seem to have just jumped to that conclusion. And that is the way we submit one rationalises their judgment, but it's wrong. because there is nothing in QBE 2 or 3 to suggest that the word only should be written in. And once you recognize that as being the court's error, then you realize that they missed out our concurrent cause argument if you get to that stage of the analysis. I want to see if there's anything. I think that's all I needed to say in relation to Mr. Graham's arguments on causation, and Mr. Keeley's argument, there was just one point that I wanted to make, because he dealt with Zurich and IGL, and I think I'm entitled to respond on that. In that case, the situation was, I think I've dealt with this in my submissions, but just in case I didn't, that Zurich's, the argument on defence costs was that Zurich was only on risk for 6 of the 27 years for which there was a claim. And so on defence costs, it could be said that but for the insured being sued for Zurich's years of exposure, the defence costs would still have been incurred because of all the other years of exposure. And so the defence costs weren't but for caused by the insured occurrences. But that it was not a submission that found favour. And it was being suggested, they didn't even find that the defence costs should be apportioned by reference to those years. Zurich were liable for all of the costs, even though they weren't a but-for cause of the allegation. The insured claims weren't a but-for cause of the costs being incurred. And then there's only one point on Mr. Gazeman where I think I've got a right to say something, and that is paragraph 278 of the judgment, which he said wasn't challenged. That's at page 114 in bundle C. And the court there, he says the court was adopting but-for, but we submit on the plain reading of that paragraph of the judgment, they're saying, well, whatever basis on which you're looking at a counterfactual, it doesn't matter, because this is the answer. There's no, Mr. Gazeman, we submit, clutching at straws to say that that is a finding in his favour, that there is a counterfactual but-for at the primary causation stage. They just say, well, at whatever stage one might be applying a counterfactual, the answer is the same. Now I come to the specific submissions that were made, and there's one which, well, I'm on Mr. Gazeman's, which I will make because it's relevant to it's a point on an appeal. It's actually on solely and directly, which he did not address orally, and he's now introduced in his reply submissions. So that is another new point, which I think I'm entitled to reply to. So that's that on his wording. And if we take Hiscox 4, it only really matters for Hiscox 4, because only that has a radius requirement. And that is, find it, it's at page, the introduction is at page 498, the preamble. Of bundle C, And the answer is quite a simple one, which is perhaps why Mr. Gazeman thought better of wasting time on it in opening, but only in desperation went to it in reply. It says it indemnifies against financial losses resulting solely and directly from an interruption to your business caused by. And the simple answer is that the solely and directly words only apply between loss and interruption. I don't disagree with him about the cause of those words, but what they're meaning is you can only get losses which are solely caused by an interruption to your business. But then what causes the interruption is subject to a different causation regime and its own causation regime. And so the words just simply don't apply at the stage of the analysis with which we are involved. So I think with those comments, I can go back to the issues on my appeal and start with Mr. Lockie. I may come back to Mr. Gazeman in turn in due course on the FCA's appeal. He says, Mr. Lockie said that the court the court below looked very closely at the prevention of access issue, and I agree that they did. But unfortunately, having taken the wrong starting point of an overly narrow approach to what prevention of access involves. And I just want to remind you again of his concession at 310, because it is important to focus on this at page 122 of recorded in paragraph 122 of the judgment, paragraph 310 at page 122 of the judgment. And it was, I did refer to this passage, but it's worth reminding you again. Towards the bottom of the paragraph, bottom third or so, Arch accepts there was a prevention of access to business in category 2 in relation to business in category 1, which did not previously provide takeaway service. Access was prevented because they could not be open to customers without a policyholder making a fundamental change in the nature of his business. And at 326, which is at page 126, Mr. Lockie fairly and properly accepts that the impossibility in question does not need to be physical or legal, because he had advice in his policy. And his concession in relation to pub and restaurant, which started a takeaway service in lockdown, or theatre, which started remote performances on the internet, are well made. That entails a fundamental change as described in the policy schedule and must be prevented. So he accepts there is a prevention of access if no one can go to a restaurant, but no one can go to the restaurant as a restaurant, but the owners and the staff are free to come and go as they wish from the premises, for example, to cook themselves meals. And they are free after the prevention of access, which closes down their restaurant, to start up a takeaway business without, on Mr. Lockie's analysis, there being a prevention of access. But he says there is no prevention of access if, in addition to cooking meals for themselves before the lockdown, they had also been cooking takeaway meals. And this, we submit, is a wholly arbitrary and nonsensical distinction. The example we gave, similar to my Lord Reed's example of Boots, the chemist, was of a department store with a small pharmacy by the front door. And the whole department store is closed. No one can come in, and no one is allowed in even if the store was open, no members of the public are allowed in, but anyone can come in to buy something at the pharmacy. And Mr. Lockie would say there is no prevention of access. But of course, if the department store said, well, we'd like to give our staff something to do, why don't we open, and the public needs access to pharmacies, why don't we set up a temporary pharmacy in the store? Then there would be a prevention of access, even though people are now coming into the store to visit the pharmacy. We submit that this is really cloud cuckoo land. Then Mr. Lockie said something about trends clauses, which is relevant to our ground one. So I have on that a full right of reply as well. He seemed to suggest that I'd submitted that there was some settled meaning to these clauses. I'd never said that there is something that the law would recognise as a settled meaning. My submission was, as I believe my Lord Legate understood it, that when one looks at the origin and genesis of these clauses, as revealed by all the textbooks going back many years, one can see what their commercial purpose actually was. And that is revealed by those texts, and that is what one construes the policy. That's the background against which one construes the policy. It's traditional in all contracts to have regard to the genesis and origin of a contract or a clause when one is construing, and this reveals what the commercial purpose of these trends clauses actually was. And when it comes to the application of a clause like Mr. Lockie's with prevention of access requirement, what you're doing is, as I've submitted, adjusting access-related losses. In some cases, the exercise may be simple, as with my church donor example. In other cases, it may be more complex, but the target is the same. The travel agent example, the calculation of access-related losses is, of course, affected by the separate legal prohibitions on travel, but they would still have to be assessed. One might, for example, assess them by reference to how online tour operators did in the lockdown as compared to the tour operator who only operated from a shop. Now for Mr. Gazeman's submissions. He referred to the meaning of the word imposed and said no one would have contemplated non-legal action. But my simple answer to that is look at the art policy. It contemplated prevention of access from advice by an authority. Of course, I'm not going to suggest that people would have had in mind what the government just did, but the fact that non-binding things might be said or done that prevented access in that case was apparent, and it was obvious there that the sort of advice being contemplated in art was something which was something that one had to comply with. And the mere fact that one doesn't anticipate this, the government lockdown has occurred, doesn't mean that the clause doesn't apply to it. In all circumstances, we have a situation which emerges, and one has to consider whether or not the policy language applies to it. In relation to Zurich submissions, Mr. Orr, just make sure there was nothing else in Mr. Crane. In Mr. Orr, he said that no one would possibly suggest that there was a trend. Oh, my Lord, sorry, yes, Lord Legate. You're on mute, my Lord.
I just wanted to ask, Mr. Edelman, why we're concerned with have to deal with Zurich policy in addition to all the others, when it appears that the point on it is completely academic and doesn't affect any policyholder, as opposed to all the other points, which affect a lot of people very importantly.
Well, I just asked my lord to remember that these are just 8 insurers which have been selected from a large number of insurers, and certain clauses have been selected. But I'm told that there are a lot of other policies out there which just use the word action.
So there are some other policies, in fact, where the point does matter, is what you're telling us.
Yes, and that's why we're appealing it. And of course, ordinarily one wouldn't, but it's because this is a test case with selected policies which have a variety of points in them. The fact that this Zurich needn't worry about this clause doesn't mean that the meaning of the concept of action in this sort of clause isn't significant.
Thank you.
All I submit about that is that no one else has made the concession, and Mr. Orr said it's not a trend, but you'll notice he didn't say whether a loss adjuster might say it was a circumstance. Of course, it might not be a trend, but the policy, they all say it applies to circumstances, and that's a point they take. So can I deal with the points, briefly with the points he made on action? And he suggested, if we go to tab 18, page 1406 in bundle C, that the fact that the policy refers to order or advice in another clause, this is clause 3 on page 1406, is relevant when one construes the word action, which appears on the previous page at 1405 at the top. And firstly, we say the draftsman has chosen different words, so we don't see that there's any contextual issue here at all. In one, it's used order and advice, and the other action. But actually, if you wanted to do anything by context, you would say action encompasses both. And action has a naturally broad meaning of meaning simply an act or thing done. And we say that that is sufficient. Let's see if there's anything else that Mr. Orr said. He then gave the origin of this clause with terrorist activities. In fact, if you look at the texts that he cites, there is a different form of words that's used. This form of language has been adapted from that, and the words have changed. But in any event, even if the clause does have its origin in a particular type of danger or emergency, that doesn't tell you what the word action means in this clause, which is not confined to terrorist activities. It just may be that someone got the idea of this form of extension because of that. And they used the word action, which is a general word. He talked about cordons, but what cordons have to do with this, we fail to understand. That may be one way in which access is interfered with, but it's not the only way. And we also don't accept that cordons are always, it always involves a breach of the law to cross a cordon. It may a police cordon, it may depend on the precise circumstances in which the cordon has been erected and for what purposes. But we needn't really go into that, because there's nothing to suggest that this is actually limited to police cordons. Yes, it refers to police, but it also refers to competent local civil or military authority. It covers absolutely every single authority that there is. And so police cordons have nothing to do with it. Then I think that the next submission I have on his approach is access will be prevented. And that's where, again, he praise and aid these old clauses. And I've just found sort of my note, the old clause said closed down or sealed off. You'll notice those words. Instead of access will be prevented, it was closed down or sealed off, which in my submission is a very different meaning. My Lord, can I just check that I don't need to say anything more about those issues? I think I've managed to zoom through it even more quickly than I had anticipated I would do. But I'm obviously wait to see if anybody sends me a message saying that I've missed anything out. But otherwise, I might have to hand over to Mr. Lynch a bit early. But unless there's any questions the court wishes to ask me in the few minutes that are remaining. But I tried in my reply to simply focus on the important points that have been made rather than just covering everything again. Try to do it succinctly. Lords, I would ask Mr. Lynch, if I'm handing over to him a bit early, certainly leave me a few minutes at the end, because there are just some matters I wish to raise which are not related to the issues in the appeal themselves, but to do with matters of, obviously thanking the court for matters of time with the judge. But I don't want to hold up Mr. Lynch, who I'm sure is chomping at the bit to get started. He may now have more than his allotted 5 minutes, because he can have 5 of mine.
Thank you very much, Mr. Edelman. In that case, we'll turn now to Mr. Lynch.
Well, Lords, I'm grateful. I may need the extra time just to work out how the video works. Again, I'm sorry about this. There seems to be some issue with it. There we are. Thank you. Thank you for your patience. My Lords, I have only one point to address in reply, and obviously I'm very grateful to my learned friend, Mr. Edelman, for the extra time, which I suspect I will not need, and he will have the extra time he requires. I just address one point, which is my learned friend, Mr. Gazeman's reference to paragraph 268 of the judgment, and his assertion that there's nothing wrong with it, linked with my answer to my Lord Legate's question to me concerning inability to use, and that question was posed to me today, draft transcript, page 46, line 13 to line 25. And just by way of reminder of that question, my Lord Legate put to me, but on the other hand, let's suppose that you can use the premises, but many fewer people can come in because you have to, or you're observing social distancing, and so you ration the number of people who come in. You couldn't say that that was inability to use, could you? Now, my Lord's question, which must of course be directed at businesses which remained open, but have fewer customers or employees attending the premises, might be, for example, an off-license which remained open, but only allowed 2 or 3 customers at a time. Now, this helpfully brings us to a number of problems we would respectfully submit with paragraph 268 of the judgment. We would draw first an immediate and important distinction here between, for example, shops which were expressly permitted to remain open and those where no direction was given under the regulations. Those businesses where no directions were given, for example, an accountancy firm, were generally and very significantly affected by, for example, Regulation 6. That prevented both customers and, importantly, employees from attending the business without one of the narrow reasonable excuses under the regulations. There was, in our respectful submission, a clear inability to use for those businesses due to restrictions imposed precisely because of Regulation 6. The fact that employees of many such businesses could work from home simply goes to quantum rather than liability. On the reduced use point generally, another example is the cinema that can still be used for remote transmission, or the church being used for funerals. There would be an inability to use for most normal business purposes although no part has an inability to use for all purposes. It means, as earlier examples we have considered during this hearing demonstrate, for example, the golf club, Boots, the restaurant, only in our respectful submission would an unreasonably narrow category of businesses fall within the approach set out in paragraph 268 of the judgment. Turning back to my Lord's question, businesses which were expressly permitted to remain open, which is, as I understand it, those businesses being considered in my Lord's question, can be and often were also affected by Regulation 6 and by other restrictions, for example, social distancing. The answer given in our written submissions is that whether or not there has been an inability to use will be determined on the facts, and the test we propose is whether this causes a material inability to use the premises for the insured's normal business activities. Please see our application for permission to appeal, paragraphs 38 to 44, A to 51 to 53, the FCA appeal written case from paragraphs 75 to 84 at B to 56 to 59, and our appeal written case from paragraphs 45 to 55 at B3 92 to 97. As I said in answer to my Lord's question in opening, it is a matter of fact and degree, but to be tested by reference to a standard of material inability to use the premises for the insured's normal business activities. With respect, this is the approach that should have been taken at paragraph 268 of the judgment. My Lords, I've used my 5 minutes, and those are my submissions in reply. That allows Mr. Edelman, I believe, the time that he requires to make his further points. Unless I can assist your Lordships further.
Thank you very much, Mr. Lynch. Mr. Edelman.
Yes, my Lord, as always is the case, there was a point that I forgot to mention. It's a very short point, and it was on the statement that the Prime Minister made on the 16th of March, which Mr. Keeley raised, which is about the restaurant point. And it's a very short point. It's bundle C, page 1783. And he said that at that page, and just above the middle of the page, we need to start people to start working at home where they possibly can. You should avoid pubs, clubs, theatres, and other social venues. And he said, well, and then he made the point that on 1784, at the top of the page, he said about Londoners, and at the bottom of the line, should avoid confined spaces such as pubs and restaurants, and said that only restaurants were only closed down in London. Well, we submit that it was obvious from the context of that other such social venues, pubs, clubs, theatres, and when he goes on to mention pubs and restaurants in relation to London, other social venues, such social venues obviously meant restaurants. Simple. That's all I wanted to say on that. Now, the final points that I wanted to raise with my Lord. Firstly, there's one thing to mention, and that is the position of ecclesiastical. You'll see that they're respondent to the appeal. That's because they have, although they succeeded on an exclusion clause, they likewise have an element of their clause, which is the subject of a declaration, because it wasn't just a general declaration. Declarations were made as to each element of the relevant clauses because this was a test case. That element of their clause will be affected. They've agreed not to take part in these proceedings and to be bound by the result because it doesn't raise any separate, their policy doesn't raise any separate issue. But I just wanted my Lords not to be taken by surprise in due course when at the decision stage and declarations, insofar as they are modified, involve ecclesiastical. There's nothing for my Lords to consider. You have the submissions as they are. but I just wanted to, just so my lords were aware of the fact that there are no additional issues raised, but they are a respondent to the appeal, so that the declaration against them can be changed if necessary and appropriate.
Did they enter appearance as respondent by putting in a notice of objection?
No, my lord, they didn't.
Well, our rules, well, you might have to think about, I don't want to go into it now, but you might want to think about what the implications are of our rules.
Well, my lord, I think that on the basis that this was a test case, and really it was just a matter of sorting out making the declaration in relation to them consistent with everybody else.
Yes, I see.
Because these are going on when the declarations are made, if they, whatever they are,
yeah,
they will be publicised by the FCA.
Yep.
And it was thought not desirable to have inconsistent declarations as the final result. You want to have a consistent pattern. So
I understand that. So I dare say once you have a judgment or judgments, you'll then want time to an opportunity to try to agree the terms of the consequent orders.
Absolutely. And that's the before I get to the very final matter, obviously need to echo all the thanks that have been expressed so far to my lords for hearing this case with such expedition and patience, particularly patience to me. I'm very grateful for that. And but obviously, having thanked you for the expedition and the patience, becomes the very awkward question about timing of a judgment. I know this was something that parties wouldn't ordinarily ask about, would accept it when it comes, but in the current circumstance, I hope my lord appreciates this question being asked.
Yes. Well, we haven't. I can tell you, we haven't yet discussed the case.
Yeah.
So I don't know, for example, if we're of the same mind, or if we're liable to be a range of views. That has a major effect on how quickly judgments take to be issued. We have taken steps to try to organise the court, the list in such a way that people should have more time than they ordinarily would have to devote to writing judgment. And because we're well aware of the practical importance of a judgment, particularly for the businesses that are affected, and we will do what we can to produce a decision just as quickly as we can. But whether that will be before Christmas or sometime in January, I can't tell you.
No, my lord, I appreciate that, because as I've explained, and I have explained to those instructing me, that this case was already squeezed into the list. And so it's not as if there was already a gap in the diary for it.
No, and unfortunately it's had to be squeezed in along with other cases being squeezed in, which for other reasons are also in their own way very important. So we'll do what we can, obviously, and we can keep the parties' solicitors informed of what the likely timetable looks like.
That would be very much appreciated if that was possible, just so expectations can be managed amongst all the policyholders. The FCA and the insurers, I'm sure, will be realistic about it, but it would be helpful for the FCA to be able to update policyholders about where things stand.
Yeah.
I'm very grateful to you, and that's all I have to say. Up to reiterating my thanks.
Well,
and of course our thanks to the transcribers and all the court staff who've made all the video link arrangements possible and operate so smoothly.
For our part, we're grateful to all counsel, particularly for managing the hearing in such a disciplined way that we got through it as smoothly as we did. As I say, we will now start putting our heads together and let you have a decision as quickly as we can manage. Thank you very much. The court will now adjourn.